What is going on, everybody? Tom Scully here with Real Estate Talk and another episode of Documents Decoded. This is where I take you through the most common documents you receive through a real estate residential transaction in Ontario. So these are OREA standard forms. And today we're going to do what's called Form 300 or the 371. We'll talk about that in a minute. Called the Buyer Representation Agreement. This is a form that you will see when you go through and you're represented by a real estate agent when you're purchasing a property. This is the standard form, and we're going through what's called a red letter form. I'm going to share my screen and I'll tell you what that means in a minute. But again, just a quick disclaimer that I do for every one of these. So the information I'm giving you here is for information purposes only, even though I am a registered real estate agent in Southwestern Ontario. The information here doesn't supersede what you'd get from somebody on your particular situation. So this is not legal advice. This isn't accounting advice. This isn't for your particular situation, but it is a heck of a good resource. So I hope you enjoy it. Let's get into Form 300 and this buyer rep agreement, and let's break it down into plain English so you know at the end what you are signing. Let's get right into it. So again, documents decoded today, Form 300 from the Ontario Real Estate Association, the OREA standard form. And that is the Buyer Representation Agreement. We're going through the red letter version today. And as you see on my screen, this is what I mean by the red letter version. There's red letters all over it. So the one you see will be different from this. This is an educational form that realtors have access to. Now, if you ask your representation, they'll be able to probably get you one of these as well so you can see it. If not, put it down in the comments. I'll send you one myself. But from this situation, this will give you a little bit of clarity. The red letters are there to break it down into some form of the King's English. The rest of it, though, I'll put in some anecdotal pieces to clarify it a little more additionally. As you see on my screen, Form 300. Now, an update, I did say 371 is an alternate paper that you can use. So Form 300 and 371 are essentially the same thing. One big difference, and I'll take a screenshot of 371 to superimpose it. And the reason why I'm not going through 371 as a red letter is because there is no red lettered version of 371. This just makes it easy, and I'll show you the difference in the two. Buyer representation, so you'll be signing one of these documents when you have a representation person or an agent essentially represents you on the purchasing side. Now, why would you ever want an agent to represent you as a buyer? Well, we look up for your best interest. We have Rolodex of partners. It usually doesn't cost you most anything. Usually that is covered by the listing of the property if it is an MLS listing. Aside from that, we go through this quite often. The big piece is always protecting your best interests, protecting you from litigation, and making sure that you're not getting yourself into a situation that's not favorable for the buyer. So I always suggest getting a buyer agent. Not only, of course, I am a little bit biased. I am a buyer agent often. However, I just think that it is very, very important for people to really have somebody who understands the process to bring you through it. So when you look at these standard forms for representation agreements for the sellers or the buyers, they're all essentially the same templates. There is going to be some slight differences between them, but what they are is they're just frameworks that legally allow us to work within to represent you properly. There are things for like communication, how we're going to do it, what framework we have for marketing the purposes, what information we might need to collect for working on your best behalf. Now, we can't do any of those things until you agree to it. So that's what essentially these documents are. They're an outline, step by step, of how we can essentially work within a framework to work on your best behalf in processing the transactions. And the first thing that we look at the top, pretty straightforward, who are you working with? The brokerage, the address, and the name of the buyers, and their addresses, the municipalities, et cetera, et cetera. And when your agreement is essentially from until. So basically the length of the document will discuss how long that your representation is representing you. Now, you get a question a lot, just because I signed this document, if things aren't going well, am I allowed to be out of the document even though we technically have this time frame that we're working within? The answer is yes. Every document can be amended, canceled, released, but every situation is different. This is something you want to discuss with your agent. I know myself, if I ever have a client that does not want to work with me, they don't like what I'm producing, I will never hold them to my document. I'll always release them. I'd rather have a friend at the end of the day than somebody who wants to go to litigation with me. In the end, for me, it's just personally not worth it. However, a legal document is a legal document, and this is one. So if someone were to enforce your representation, they may have the option to do so. Different depending on everybody's situation, so definitely take a look at it. The one part that I wanted to show you and it's going to be right here. So the difference between a 371 and a 300 is what's called designated representation. So we'll be going through this a little bit later, and if you've seen this on the seller's representation agreement, we've already discussed it, and I'll have a link up and down below. The designated representation came through some changes from OREA in 2024. We had a lot of convolution when it came to multiple representation, and we'll get into this shortly, but the portion for designated rep that you'll see on your screen right now will basically outline the specific representative through the brokerage who is working for you. That is, what you typically and colloquially call your agent. Now, this has been something that, again, we're going to discuss shortly, but it has to do a lot with the multiple representation faction and, outlining more specifically who exactly represents you in your transaction. So Form 371, the only real major difference is the designated representation, but that's likely the one you're going to work with, as most people are using that now going forward, now that it's 2025. Get into the rest of it, you'll see a bracket that you have to initial. Initial is essentially the length of the agreement, so you're understanding the length of the agreement that you're working in. And then underneath here, this is going to be essentially outlining what type of property you're looking for. Now, we're kind of discussing residential mostly in these documents, so what you're usually going to see is single-family residential or just residential. But, we do a lot of things, commercial, industrial, multifamily residential, farming, etc., etc. It can be a pretty broad scope that's in this, but you'll see outlined, especially in this first box, property type. And then the box underneath that is geographic location. Some people get specific with this. Some people keep it to the size of the county. Some people just say Canada. It could be for a lot of reasons. If your agent is working with you across the nation, then if they're licensed to do so, they're welcome to do so. Very few people are. But geographic locations, obviously the area in which you're looking, and then you'll be acknowledging down here as well, warranting that you're not doing this with any other representation. So you have no other buyer representations agreement that are currently enforced, and we go forward from here. Underneath, of course, because every one of these has one, is Schedule A. We'll see this a little bit later. These are any attachments to the back of the document. Sometimes you'll have additional schedules, Schedule B, Schedule C, Schedule D. This is kind of where they will be notified, just to make sure that the document is complete. If somebody sees that it's not just a Schedule A, there's a B and a C, they want to make sure those are all together and attached, and one happy family of a document is together. Classic, just a quick little battery change right in the middle. Let's just get back into it. So we're at definitions and interpretations, and if I haven't said this yet, let's go through this really briefly. What you're going to see for the clauses underneath the pre-printed clauses, this is the framework that allows the realtors and your representation to work within in order to give you the best service possible. And as simply as seen on the screen right now is, this long wordy clause that basically states and outlines all the definitions and interpretations for the standard terms that you're going to use. The purpose for the agreement, with the authority of the agreement, the buyer, what is a buyer, and the seller, what is the seller, etc., etc. So you're going to come into some wordy things such as that, but essentially that's all that is. So definitions and interpretations is the form that defines the terms that follow in the document. Commission, of course, that's one that we always discuss. That's always going to be one of the first things people ask, of course, is, what's this going to cost me? And that's a very good question. So with respect to commission, when it comes to a buyer's representation agreement, it's a little bit different than obviously the seller's representation agreement. And there may be some changes coming down the pipeline, but we'll discuss that on another day. But the red letter states, the section of this agreement sets the structure for the commission to be paid to the real estate company. It states that the buyer agrees to pay a commission to the real estate company, the detail of which is set out in this section. The real estate company is entitled to the commission when the buyer enters into the agreement to buy or lease a property. The buyer agrees the commission may come from the listing brokerage or from the seller. If it turns out that there isn't enough, the buyer will make up the difference. Here's the piece on the buyer's side. And here's the two things that you'll most commonly run into. Now, a lot of agents, like what I do for myself, when it comes to the commission portion, you'll see obviously a few lines here, the commission of percentage of the price, or, and if it's a lease, this is this portion down here. Now for me, I always put in this box right here, and this is how I always operate myself, is as per MLS agreement, right? So I go by whatever the listing brokerage goes by, and most people do. But some people don't. Some people will say that it is 2.5% of the sale price, or 2% of the sale price, or 3% of the sale price, or fixed commission, which is also common to see. So a fixed commission, if it's somebody they've worked with multiple times, maybe they want to do a fixed commission. And then down here for a lease is where they would notify that. So what may happen is if it doesn't say as per MLS, if it says 2.5% or a fixed rate, it'll depend then on the MLS agreement if you are gonna have to pay anything. So if somebody says it's 2.5% of the sale price, that is the buyer's commission. If the listing agreement states that only 2% is going to the cooperating brokerage or the buyer's representation, then that 0.5% may be enforced on the buyers to pay their representation. So please pay strong attention to this and make sure you have this conversation with your real estate agent on how they go about producing their buyer's agreements, because it makes a big difference. Obviously, if you're looking to buy a property and you're not focusing or you're not putting enough money aside for your buyer representation, and it comes back that you have to pay $3,000, $4,000, $5,000 to your buyer rep, well, it's a big conversation to be had. So be very clear on what is put in the commission portion. Most commissions are just covered by the listing agent, but not all. So please be wary of what is in your document. Next, representation. And this is where the designated representation portion from the 371 form is very important. So down here, representation discusses, obviously, confirms that the real estate company and the salesperson have explained the different types of agency and other relationships that may occur in a real estate transaction. So what we're handing out now to all of our clients in Ontario is a new form called the Real Estate Information Guide. OREA, the Real Estate Association in Ontario, has put together a really plain English document called the Real Estate Information Guide that you will go through and sign the back of when you receive it to make sure you understand all of the information. That will break down in plain English all the different types of agency and relationships that they have between the buyers and the sellers and the clients and whatnot. Most of which are, like some limited service agreements or some, non-representation sales agreements. But most of which that we deal with on a regular basis are standard client agreements, all of which are broken down in that document. Now, that's the first part of this representation clause. The second part is going over multiple representation. Now, what is different, and that will be a little bit different on the 371 because they've updated it, is nowadays in multiple representation, it's slightly changed from what it was last year at this time. Historically, multiple representation was if you had a client that was represented by the same brokerage in the transaction, you were technically in multiples. You had to notify that, you had to agree to it to proceed in the transaction. That could have been multiple buyers on one side that were under the same rep, or the buyer and the seller represented by the same brokerage. The reality is with brokerages, like for instance the one I work with, which is Royal LePage Binder here in Windsor, Essex, we have a considerable amount of agents and they're all very good people. I don't know half of them, but I'm sure they're great. The problem there lies in, I have no idea because we're all essentially independent for the most part, with the exception of the teams working underneath the brokerage. So even though we're independently working, we have the same underwriting company. I don't know their clients, they don't know my clients, but technically it's multiple representation because of the same brokerage. But we could have no idea what these people are doing. Now, with the update of designated representation, to have or to be in multiple representation, you need to have that designated rep representing the seller, the buyer, or a couple of the buyers that are proceeding on one property, which kind of clarifies that that's real multiple rep. If I am selling a property and I have a buyer come in and they're also my client, they both have representation agreements, that is multiple representation. Now, there is some side notes here because they could have limited service agreements in which they wouldn't be getting fiduciary obligations. That's not multiple representation. But again, go through this with your representation, understand it clearly what is and what is not multiples. And it's pretty clear these days, so they basically have to be designated to be full clients to be multiple reps. But this is what this clause outlines, and it's pretty straightforward now with the RECO Information Guide. Let's go on to number 4, referral of properties. So pretty straightforward here. The buyer is committing to work with the brokerage and agrees to communicate to the brokerage any interest in any properties that come to the buyer's attention. The buyer will be responsible to pay commission to the brokerage if the buyer purchases a property during the term of the buyer representation agreement or the holdover period. Important to note this as well. when you are in a representation with a buyer agency, you need to, of course, just disclose anything that you're interested in so we can do our due diligence and do the best thing that we can for you, protecting yourself, giving you all the information and all of the things that you're essentially paying for. If you are in a buyer rep agreement and you go ahead and purchase a property without telling us, well, there can be a litigation for that. So, be forthcoming with all the information. Make sure you are not hiding anything from your rep, especially if you sign an agreement, because there could be some litigation if you do not. They said holdover period in here, and I didn't go over that, but a holdover period would be in this commission portion here. And I'm gonna go back to it. So number 2 in commission, you'll see these dots down here. So this is basically discussing the holdover period. So if you looked at a property with a buyer or your buyer rep, you like the property, but you didn't put an offer in on it, you waited for your representation to end, and then you went and put an offer on it within the time frame that this document states in these dots, then the buyer representation may be entitled to that commission still. So please note those 3 dots, or those few dots are very important. That holdover period is very important. Typically it's 60 to 90 days. Again, have that conversation. Every agent is different, and to each their own on how they produce it. Going down to indemnification. This is something that protects the agents themselves. So the buyer acknowledges that the salesperson and the brokerages are not qualified to determine the physical condition of the property, and the buyer agrees that the brokerage will not be liable for any defects. This is discussed often. The first piece of advice I give to any buyers is please get a home inspection. I still think it's the most important thing about buying a home is to make sure that you're comfortable buying the property. You don't have any headaches, hopefully later, or at least you know what you're getting yourself into. The people who do these inspections are also insured. So if they had missed something or negligible, then they may be liable as well. But what this showcases is that when your agent is going through your home with you, or your rep is going through your home with you, they can point out a few things, but they're not experts. They're not building experts. They're not mortgage experts. They're not legal experts. And you can't hold us to any of that information as far as calling it legal or expert advice. Always get an expert in any particular field to give you the right advice every time. That should also be the advice your representative gives you. We have Rolodexes full of people that are experts in their fields, from lawyers to mortgage to every single thing. So there's no reason why you shouldn't be getting that information. But that portion here, indemnification, just showcases that we are not experts in any other field besides real estate. So that's that. Finder's fees. Number 6, so this is a clause that just showcases that essentially real estate agents and their brokerages sometimes receive a referral fee or a finder's fee for referring a client to expert advice, for instance, the indemnification. Now, it does happen sometimes, it's not all the time, but when that does happen, they should disclose it to you, and this just letting you know right here that that does happen. But again, if your buyer agent is getting a kickback, they should notify you of such kickback. Next, we have 7 consumer reports. This is heavy and bold. This is just a acknowledgement essentially from your side. So the buyer acknowledges that the credit checks and personal information may be referred to in the process of purchasing a property. Doesn't happen as much for the real estate agents, but does obviously happen for mortgage professionals, legal professionals. When you go through the title transfer, that happens as well. So, this gives the people that need the acknowledgement to do so. Number 8, use and distribution of information. So the following section gives salespeople the right under the privacy legislation to use the personal information provided to them by the buyer in order to assist in making the transaction happen. It also assures the buyer that this information will not be distributed to third parties, for instance, pool companies, move companies, etc., etc. This goes to marketing as well. So post-sale marketing, we can't just take your information and go, hey, so-and-so bought this house for so-and-so amount. We can say house sold, buyers are happy, etc. That's fine, but we can't give your personal information, the purchase price of the property, etc., without your acknowledgement to do so on a separate document. This also lets you know that, of course, we're not going to use your information in bad faith, but we are going to use what we are allowed to, what's listed in this clause, basically just simply in the purpose of purchasing the home for you. Number 9, discrepancy or conflict or discrepancy. A little bit of back and forth there. This has to deal with these pre-printed clauses. So that Schedule A that we're going to get to shortly, you can put a lot of things in that Schedule A. If there is anything in Schedule A or anything thereafter in this document, Schedule B or Schedule C, etc., if there is anything that conflicts or has discrepancy with any pre-printed clauses, that will supersede the pre-printed clause. That's what number 9 is talking about. So if there's a conflict or discrepancy between what comes later and what is pre-printed, what comes later takes precedence. Successors, another good example of that. So say Schedule A, you want to say for the fees, let's say for the fees, there is a fixed flat fee unless etc. happens or whatnot. That will supersede then, up top when you look at the commissions. It's just one example, but if something out there, something in Schedule A discusses commissions and how it's going to be paid out, that will supersede everything in number 2 commission for the pre-printed clause. So that's what they mean by conflict or discrepancy. Number 10, successors and assigns. We hope to never use it. I say that every time I see it. Essentially means that if anything were to happen to the parties involved that are the undersigning people of this, the buyers of the agreement, then the heirs, executors, administrators, and successors are bound to the agreement as well. Now, let's just hope everybody is healthy and happy, but that could be imposed if that situation were to arise. Now, 10 and 11 are pretty straightforward. They basically have to deal with electronic communication and binding agreements. Number 11 is saying that communication of electronics kind, or let's just say that clearly here, that electronic communication of any kind is a viable meaning of binding the property or the sale of the property. Number 10 is saying, or number 12, long day today. Number 12 is saying the clause provides consent to the parties' electronic signatures with respect to the agreement, and that is also allowed to be binding for the property. This obviously came through when everybody's using, their thumbs on their phones a lot more. Now, very, very rarely will you see handwritten or hand-signed documents, but it does happen, for sure. But this is allowing us to bind the agreement using electronics. Pretty straightforward on that. And then down to some fun pieces. Pretty straightforward. For the next, we have the authorization to bind the agreement. This is where your representation will sign here, your designated rep, name of their signing, the date. And then underneath that, this is the important part, of course, these little black boxes, signed under seal. That means that this is a legal document and it can be imposed in the court of law. And then this is your buyer acknowledgement that you have read and understood the terms of the buyer's representation agreement. And of course, when you sign there, that makes you guys now representative, or having representation, sorry. Declaration of insurance, this is for your buyer rep. Declares that they do have insurance, just in case they need to use it. And then down here, the acknowledgement that you fully understand the terms of the agreement and you've received a copy of your agreement. If you do not understand any part of this that you're going through with your representation, don't sign these portions. When you do, you don't really have any recourse to say, I didn't understand. So please don't sign these bottom pieces until you fully understand all of your questions are answered, because these acknowledgements down here state that you do. And if you sign that and not knowing what you're signing, well, you're still bound, unfortunately. Schedule A, this is what you'll see at the very end. Sometimes, again, there's Schedule B, Schedule C, but most of the time you'll just have a Schedule A. And this will showcase, usually written through here, what your buyer representative is doing for you. So they'll be outlining, their rights and responsibilities and their due diligences, and this will be discussed over here. So that's pretty straightforward. That is the Form 300/371. Not an overly long document, but this representation is very important. I highly suggest that when you do sit with your buyer rep, that you go through the most important things. The commission, of course, is a big one. You want to make sure that you don't have to be out of pocket for anything. You want to make sure you understand fully what multiple rep is and what client representation is. And then just make sure you're fully, completely, no questions on anything else. It is pretty straightforward for the most part for a buyer's rep, but still, I always say never sign anything until you have no questions. Always be prepared and well informed if you want a really smooth real estate transaction. Form 300, hope you liked it, hope you found it informative. If you did, you know what to do. The like, the share, the fun things. Most importantly, I'm gonna be putting a lot of these out. So this is something that you wanna look at and something that you like. I would love it if you just subscribed. That would be awesome, and I'll just keep doing it. If nobody likes them, that's fine. I'm gonna keep doing them probably anyway, but you know what? It's much cooler to see that people enjoy it. Thank you very much again. Tom Scully, Real Estate Talk, documents decoded, buyer representation agreement. Take care. Have a good day.